John Bolton believes presidents can rescind treaties without going to the Senate, but objected to President Donald Trump pausing military aid to Ukraine, a non-treaty partner. Hello, this is Robert Romano, Vice President of Public Policy with Americans for Limited Government, dailytorch.com. Hit that subscribe button. Today we're going to be talking about former National Security Advisor John Bolton. He was fired on September 11, the same day that military assistance to Ukraine was released by the White House and the Office of Management and Budget. It had been frozen in July while the administration considered a rescission and also was contemplating U.S. policy towards Ukraine with the new president, Zelensky, who only got elected in April, and just basically considering our overall posture there. The pause in military assistance to Ukraine has now become the subject of the Democrats' quest to impeach President Donald Trump, and one that I believe is doomed to failure. So let's get into this a little bit. John Bolton, he's kind of fashioned his career around the idea of presidents basically abrogating treaties on a kind of very conventional historical view under Article 2, executive powers, the sole vesting of the executive power in the president. And so the legal context for this is, for example, in 1793, President George Washington suspended a treaty with France, a mutual defense treaty, when France had been overthrown by the French Revolution. The monarchy there was no more, and then France was going to war with Great Britain, and so there was a question about whether the U.S. would honor the treaty, and Washington said, no, we're not going back to war with Great Britain, so that's just not what my administration is going to do. So Washington kept us out of the war. Other presidents who have abrogated treaties include FDR pulled out of a treaty with Japan in 1939. Jimmy Carter pulled out of a mutual defense treaty with Taiwan in 1979. George W. Bush pulled out of the anti-ballistic missile treaty in 2002. At John Bolton's advice, he was a supporter of that in the Bush administration. And President Trump has withdrawn from the Intermediate Nuclear Forces Treaty from 1987. Just this summer. And again, that was under the advice of Ambassador Bolton here. But in the meantime, he has been siding with State Department officials who took issue and Defense Department officials with Trump briefly pausing and reviewing military aid and other foreign assistance to Ukraine on the grounds that the president lacked legal authority. Now, the funding included $250 million for military assistance, as well as $141 million for other foreign aid to Ukraine that was via the State Department. So you had defense spending and state spending that was being invoked here. And according to a November 9 report from Bloomberg, quote, shortly before September 9, Bolton had relayed a message to the State Department that the funding could go ahead. It's not clear whether Bolton, who resigned from the job a week earlier, did so with President Trump's approval. Bolton's handling of the funding struck officials in the White House as violating protocol and caught Mulvaney, Mick Mulvaney, he's the chief of staff and the head of the Office of Management and Budget, by surprise, according to another person familiar with the matter. An OMB spokesperson, however, denied that this had occurred, so there's some disputing from the White House about this reporting. But leaving that aside for a moment, the report continued noting that the State Department had concluded on its own that it could release the monies without OMB approval. Quote, the State Department's decision, which hasn't been reported previously, stemmed from a legal finding made earlier in the year and conveyed in a classified memorandum to Secretary of State Mike Pompeo. State Department lawyers found the White House Office of Management and Budget, and thus the president, had no legal standing to block spending of the Ukraine aid. Now, former Ambassador William Taylor on October 22nd actually testified about this. And what he said was, probably after a July 18 meeting, the State Department and maybe the Defense Department decided they were going to move forward with this assistance anyway, OMB notwithstanding. This was a big decision from L, I think that means legal, came over there over some debate as to whether or not they could do it without OMB's clearance, send a congressional notification to the Hill without OMB's clearance, and they decided to do that. I don't know if they've ever done that before. This was a big decision at the time. So as far as you know, that was unprecedented? Question. from Taylor, quote, "as far as I know." So that's pretty remarkable that the State Department and the Defense Departments believe that they can spend monies without going through OMB and without the president's approval if he's considering a rescission, which he was at the time. This is clearly a dispute between the State Department and Defense Departments and the White House over freezing the monies, and the department had even produced, the State Department side, a self-serving legal opinion that it could spend the monies without OMB. And I find this to be a dubious statement, since all monies and regulations flow through OMB. That way nothing's happening on a regulatory or spending standpoint that the White House is not just double checking, making certain it's in accordance with the law, and other obligations, international law, for example, that the administration has to contend with, and also presidential discretion. The funds were initially frozen in July by the OMB under the agency's authority under 31 U.S.C. 1512 to conduct apportionments. And we've looked at this before. This is basically the code that gives OMB, just the reason why all the monies are flowing through OMB. And it just has to be double checked to make certain that things are in accordance with it. And there's certain limited circumstances for which it can be delayed or frozen. Now, also, the president has the power to consider rescissions, deferrals, and rescissions. So under the Impoundment Control Act of 1974, here's the code for 2 U.S.C. 684 for deferrals, 2 U.S.C. Section 683 on budget rescission authority, and the apportionment for OMB authority, that's 31 U.S.C. 1512. And so moving forward here, the Office of Management and Budget is saying it has done nothing wrong, however, with Communications Director Rachel Semel issuing a statement saying, quote, "has been well documented. We fully complied with the law and decades of precedent with respect to these funds. Congress is notified if the administration intends to rescind, defer, reprogram, or transfer funding. But in this case, none of those things occurred, and the funding was obligated as planned." And so this came as part of a wider freezing and review of foreign aid packages over at the State Department and at the U.S. aid organization. And many countries were actually having their foreign assistance held up at the time. So Ukraine was not unique in this regard, although they might have gotten a bit more special attention given the kind of dynamics that are at play in Ukraine vis-a-vis U.S. policy. Trump was considering pausing the military assistance and considering a rescission in this case. In the wider review, the OMB was asking for an accounting of unspent balances from the years prior, and then that aid was actually released much, much quicker. In the case of Ukraine, Trump was contemplating, frankly, a policy change, which, as the President of the United States, under Article 2, executive power is vested solely in the president, and that includes all of the foreign affairs powers, including the powers to enter into executive agreements, to make treaties, and then to seek the Senate's consent in a treaty. But the president's the one who negotiates a treaty, and so this is clearly squarely in the president's, I think, wheelhouse here on foreign affairs to consider rescinding military assistance to a country that Trump is saying maybe is corrupt. Now, in a conversation between President Trump and Senator Ron Johnson, and this was big news, on August 31, he says he had a conversation, and he details this in a November 18 letter to members of Congress. And here he's writing to Jim Jordan and Devin Nunes, who are considering the impeachment inquiry. And the reason for his letter, ostensibly, is that he has information that is relevant to the House's inquiry. And so the president wanted to speak to Ron Johnson when he called the White House about these issues. And on August 31, President Trump gave him a call back. The purpose of the call, according to Johnson, was to inform President Trump of my upcoming trip to Ukraine and to try to persuade him to authorize me to tell Zelensky that the hold would be lifted on military aid. The president was not prepared to lift the hold, and he was consistent with the reasons he cited. He reminded me how thoroughly corrupt Ukraine was, and again conveyed his frustration that Europe doesn't do its fair share in providing military aid. President was telling Johnson that the Germans think that the United States and the American people are schmucks because we give the money and they don't have to give any money. And eventually, Trump gets around to telling him, Ron, I understand your position. We're reviewing it now, and you'll probably like my final decision, hinting that he was going to release the aid anyways, which he did on September 11. And so note this conversation is before the anonymous CIA so-called whistleblower's complaint became public, and that we knew that we were heading towards impeachment. So before any public controversy, President Trump was already saying that the reason why for the freeze is we're evaluating our relationship with Ukraine. They're very corrupt, and we want to look into that and make certain that they're a reliable partner before we dispense with this military aid. And so there was this brief review occurring here. Ultimately, the military assistance was released days after the same day Bolton was fired, and days after he had reportedly ordered the State Department aid to be released. Again, on September 9, according to Bloomberg, Bolton had relayed a message to the State Department that the funding could go ahead. And so there's a question about whether or not President Trump had authorized Bolton to do that. Which is kind of curious, but in any event, he's siding with the State Department, which has already kind of claimed the power unto itself to release the monies without going through OMB, because I guess they felt like, oh, this is an emergency. We have to act. We have to resist President Trump. He's a stooge of Putin and Russia and that all that nonsense, all that debunked conspiracy theory nonsense that apparently State Department officials are operating under an assumption that the president is some sort of foreign agent and he's not legitimate. Vladimir Putin helped President Trump get elected, and all that nonsense that, frankly, Special Counsel Robert Mueller debunked in his report, a 2-year-long investigation that found there was no conspiracy between President Trump, his campaign, and Russia to hack the DNC and John Podesta emails and put them onto WikiLeaks. They're not George Papadopoulos, not Carter Page, not Michael Flynn, not Paul Manafort, and not Roger Stone. Nobody, not Michael Cohen. Nobody was charged with crime of conspiring with Russia on the DNC and Podesta hacks. It just didn't happen. There wasn't evidence for that. President Trump wasn't charged either. And I think if they had found evidence of that, the Mueller team would have included that in their report. They didn't. And so here's Bolton. He's siding with the State Department and trying to get this military aid released without OMB. In the meantime, Bolton has long fashioned his career around the proposals to eliminate treaties with foreign governments, particularly on nuclear policy. We mentioned the INF treaty that he encouraged President Trump to get out of. Trump did. And also the ABM treaty, the 1972 ABM treaty that he helped to persuade President Bush in 2002 to pull out of. Now, in his book, during the administration of George W. Bush, he was a supporter of getting out of the 72 anti-ballistic missile treaty. Bolton wrote in his memoirs, and you can see this book. It's called Surrender is Not an Option, Defending America and the United Nations and Abroad, speaking of his time in the Bush administration. According to Bolton, quote, it was absolutely critical to get out of the ABM treaty unambiguously. Then whether we succeeded or failed in broader negotiations with Russia, we would be free to pursue a missile defense program system to protect Americans from current threats. And he calls it these treaties sacred scrolls by arms control advocates who are trying to keep the treaties in place. But if anything, the argument against pulling out of the ABM treaty is that it would undermine other nuclear security agreements and result in nuclear proliferation, under the theory that if we were building missile defense systems that were previously forbidden under the ABM treaty, then Russia would move to counter U.S. missile defenses, which now it has done. It turns out that that was correct. They've pursued the hypersonic missiles, which now we say is a violation of the INF treaty. And so then Bolton says, well, we need to get out of that treaty as well. Which, by the way, I agree that presidents have the executive authority under Article 2 to do that. In fact, there's a 2001 Justice Department Office of Legal Counsel opinion detailing the authorities. This was November 15, 2001, memorandum for John Bellinger III, Senior Associate Counsel to the President and Legal Advisor to the National Security Council. And this was from Deputy Assistant Attorney General John Yoo and also Robert Delahunty from the Office of Legal Counsel. And what it found was that the presidents most certainly can withdraw from treaties, suspending them. We mentioned the 1793 Proclamation of Neutrality, FDR getting out of the Treaty of Japan, Jimmy Carter getting out of the Taiwan Treaty. Yu and Delahunty wrote, quote, "The president's power to terminate treaties must reside in the president as a necessary corollary to the exercise of the president's other plenary foreign affairs powers. As noted before, the president is the sole organ of the nation in regard to foreign nations. A president, therefore, may need to terminate a treaty in order to implement his decision to recognize a foreign government. Or, for example, the president may wish to terminate a treaty in order to reflect the fact that the treaty had become obsolete, to sanction a treaty partner for violations, to protect the United States from commitments that would threaten its national security, to condemn human rights violations, or to negotiate a better treaty." Now, in 1793, Alexander Hamilton, he was at the Constitutional Convention, and he argues in the Federalist 70 for the unitary executive power, and spoke out against kind of executive power by committee. He says, no, we get one president at a time. And that was the view of the framers who adopted the Constitution. In 1793, now in the Washington administration, Alexander Hamilton was justifying the Proclamation of Neutrality, where he wrote, "Though treaties, quote, can only be made by the president and the Senate, their activity may be continued or suspended by the president alone." Now, Bolton, he would later pen an op-ed with Yoo, the same John Yoo that wrote this 2001 legal opinion, advocating for the withdrawal from the INF treaty. He wrote this in 2014. And ultimately, Bolton and Yoo were successful. President Trump got elected, and he did pull out of the INF treaty. Now, treaties require Senate supermajority in order to be ratified under Article 2, but in this understanding of constitutional law, because of the president's plenary powers over foreign affairs, he alone can terminate the execution of a treaty and just get rid of it. So what of foreign aid? What of the powers to keep the U.S. out of war or to end a war? These are actually very important parts of almost untested areas of constitutional jurisprudence. Even in cases of treaty termination in 1979, Jimmy Carter prevailed at the Supreme Court level on pulling out of the Taiwan Treaty with instructions to the lower court to dismiss the case. However, it was on grounds of non-justiciability, meaning they couldn't hear the case really, and so they never actually proceeded to the merits. So how do you pull out of a treaty? Well, there's been numerous examples where presidents have had the power to do that, and so that's where Trump is operating under with INF treaty, and with the Bush with the ABM treaty, Carter with the Taiwan treaty, FDR with the Japan treaty, and President Washington in the Proclamation of Neutrality. Now, the foreign military assistance surely treads on the areas of the president's discretion. Here, now we're talking about the Ukraine military assistance again, as does the receiving country, requiring at least executive agreement to receive the assistance, or an agreement of a faction within the country if the U.S. was supporting one side in the civil war, as we've done in Ukraine since 2014, and then again in 2017 when we began sending military assistance. But here's the thing, the U.S. and Ukraine do not have a mutual defense treaty. What we do have is this Budapest Memorandum on Security Assurances. And what it states is that we'll defend the territorial integrity of Ukraine. And this was a U.S., Russian, and United Kingdom agreement. And it was about welcoming the Ukraine into the Treaty of Non-Proliferation on Nuclear Weapons as a non-nuclear weapon state. And we were persuading Ukraine to give up its nuclear weapons after the fall of the Soviet Union, and the U.S., Russia, and UK were going to guarantee their territorial integrity. And what it included was, provisions against interfering in Ukraine's internal affairs, which basically everyone's been violating lately. In 2014, we supported the overthrow of Viktor Yanukovych's administration. That seems to have violated the security assurances. Russia annexed Crimea. That's another violation of the security assurances. Obama opted not to send military assistance to Ukraine, despite the fact that Russia was invading its country and taking over territory, which violates the UN Charter, which the in accordance you can send weapons or use weapons in Ukraine, but only in self-defense or otherwise in accordance with the Charter of the United Nations. And so what that means is, if a country is engaging in aggression against Ukraine, then you can use weapons there. So that would be the justification under international law for sending military assistance there. Now, Obama decided not to send military assistance. It was President Trump who decided to send military assistance. Probably the reason Obama was reluctant to send military assistance is because U.S. and Russia fighting a proxy war in Ukraine could trigger a wider war between U.S., Russia, Europe, and could lead to the possible discharge of nuclear weapons, and that would be a catastrophe. So I think trying to stabilize Ukraine is in everyone's interest. It's in the interest of international peace and security, as a matter of fact, which is also in the UN Charter. Now, President Trump, he signed the military assistance into law, but he must retain the power to oversee the execution of that law, consistent with international law, which the president alone interprets. Under the Constitution, it is the president who has to interpret treaties and other executive agreements, and that's what the Ukraine Security Assurances agreement was in 1994. There was no treaty per se. It wasn't ratified by the Senate, and so there's an executive agreement. If the president feels like we can't honor those commitments, he's allowed to review that decision. The agreement bars weapons against Ukraine, except for violations of the Charter of the UN or self-defense. We've mentioned the annexation of Crimea. It's also a violation. It also has provision that neither U.S. nor Russia would use economic coercion in Ukraine to advance their own national interest, reaffirming commitments to, quote, refrain from economic coercion designed to subordinate to their own interests the exercise by Ukraine of the rights inherent in its sovereignty and thus to secure advantages of any kind. But that didn't stop Congress from attaching terms and conditions to the military assistance to Ukraine, to Defense Department certifications. And this was in the laws of extension, enhancement of Ukraine's security assistance, most recently enacted in the National Defense Authorization Act, and it being re-upped by Congress. We're conditioning military assistance on DoD certifications showing, quote, improvement in transparency, accountability for the purposes of decreasing corruption. So even if Trump had tied military assistance explicitly to Ukraine on some sort of anti-corruption statement and investigations into corruption from natural gas firm Burisma, for example, he could have done that because he could have directed the DoD to pull back a certification unless there was this statement. Trump didn't do that, but he could have, under the law. What he's accused of would have therefore been consistent with the law. There are also limited means of limiting the use of the monies under what's known as transfer authority. And what this goes to are DoD or the Department of State. In either case, they can move monies around to items that are higher priority. So if Trump had wanted to, he could have transferred money away from Ukraine military spending and said, no, we need the money over here. Same deal under foreign aid. The president can transfer foreign aid around via the budget, and that's perfectly legitimate and well within the scope of the president's authorities under the Constitution and under statute. I think that it's a normal course of business. So if the president wanted to, he had a menu of options for directing departments and agencies in either freezing, rescinding, or transferring the funds in question, which all of these decisions have been authorized by Congress. So Congress and members of those departments and agencies are faulting the president for even considering doing that and decided that they were going to act of their own accord. And here, though, under Article 2, it's the president's decision to make, and he can do so if he wishes. What happened here was a power grab by the State Department and Defense Department. If Taylor's testimony that they plan to dispense foreign aid, whether the president liked it or not, and perhaps even with former National Security Advisor Bolton's acquiescence, if the reporting from Bloomberg is true. Now, if treaties can be terminated, here's the argument, by the presidents alone, then concluding military commitments via foreign assistance by the U.S. must rest with the president as well. In the past, there have been presidential determinations when hostilities have concluded, or else Congress could, or when U.S. assistance in commencing hostilities are included, and that can occur via ceasefire and armistice. The president could be suing for peace in the event of war, and he could be trying to change our foreign policy, which is his job as the president. He's the one who sets the policies. And we only wanted that in one person, the president, under Article 2. That's what the framers envisioned. So that's what Federalist 70 says. It's the unitary executive power, and certainly primacy in foreign affairs goes to the president. He's the one who makes executive agreements. He's the commander-in-chief in the operation of a military, so he can clearly declare a ceasefire. And John Bolton, he's argued that presidents can even terminate treaties, which require supermajority to ratify. But he's saying the president doesn't have the authority. The State Department saying the president doesn't have the authority to review, while pondering a rescission to Congress of military assistance to Ukraine. That's absurd. It's a congressional commandeering of the commander-in-chief and foreign affairs powers under Article 2. That's the power grab here by the administrative state and by Congress. The Supreme Court ruled in 1919 that on technical states of war. This is the Goldwater decision. Here's the 1919 decision, Hamilton v. Kentucky Distilleries and Warehouse Company. And what the court found there was, quote, a technical state of war is terminable only with the ratification of a treaty of peace or a proclamation of peace. Now, the issue here was that the United States had ended World War I, but we didn't have a peace treaty with Germany because the Treaty of Versailles had not been ratified by the Senate. And so there was a problem with these wartime provisions of law that were still in effect and whether or not they were still in effect. And what the court ruled was that, yes, they are still in effect. You have to go by the wartime provisions that were still in effect, and that the only way to end it would be a peace treaty or a peace proclamation by the president. Woodrow Wilson at the time, he said, I'm not going to do a peace proclamation because he was trying to encourage the Senate to ratify the treaty and then the League of Nations, and the Senate refused. Eventually, the new president, Warren Harding, in 1921, he had a formal peace treaty ratified with Germany, but not before he had issued a proclamation stating that the formal state of war with Germany had ceased 4 months earlier. Truly interesting period of history. This is from a University of Chicago legal paper. Quote, on November 14, 1921, upon ratification of the peace treaty, President Harding issued a presidential proclamation stating that the legal state of war with Germany had concluded 4 months earlier on July 2 of that year. Under the rules set forth in Hamilton, this action should have been considered sufficient to end a war. In Miller v. Rouse, Judge Learned Hand heard an alien property custodian claim for a demand served on July 5, 1921. Judge Hand denied the claim because it had been made 3 days after the declaration of peace as now promulgated by the president's recent proclamation. Thus, consistent with Hamilton, Judge Hand took the presidential proclamation of peace as setting the date as to the legal end of the war. This is, again, a truly fascinating topic of constitutional. This is from Mark Mosier, The Power to Declare Peace Unilaterally, and he's saying, consistent with Article 2, it's an argument. I mean, these are all complex constitutional questions, believe me, and much more learned folks than myself will have a different opinion about this, but it's a legitimate debate. It was a legitimate debate. All of these issues, presidential powers, nothing was more debated at the Constitutional Convention than the presidency. And so I think this is an interesting argument, and who has the power to end a war, who has the power to terminate a treaty, who has the power to to terminate military assistance or to say we're going to review it. I'd say that's the president under Article 2, and the precedents are quite clear on that count. So I find that the Harding example, the peace proclamation that upholds executive power to end a state of war under the president's inherent Article 2 powers to end a treaty. And so it is conceivable that the president could impound military assistance overseas under those same powers that might cause the U.S. to otherwise become obligated in a war if the president was concerned about the national security implications. And in this case, we're talking about non-treaty security assurance obligations with Ukraine that might drag the U.S. into a wider war with Russia and the possible discharge of nuclear weapons, which could basically make humanity go extinct. We could all die if there's a big fight over Ukraine between the U.S. and Russia. But it's the position of the National Security Council resistors, including Bolton, that President Trump or any other president can terminate this executive agreement with the UK and Russia on territorial integrity of Ukraine. But that the president can't review the military assistance that's being used to wage war there. This is an area of power, therefore, where to conduct under foreign affairs, where something has to give one way or another. And so Article 2 appears to facially side with the executive. But these are all complex constitutional questions. Courts typically resolve these types of disputes between the branches. And that would be legitimate if President Trump had, for example, said, yes, I'm impounding these funds and we're not sending the military aid, then you can have a court case. And Congress could object and say that we think that money should have been spent. The president could say, no, under my foreign affairs powers, under Article 2, I have the power to impound these monies. And then we would find out if the Impoundment Control Act, as it relates to foreign aid, is constitutional or not. That would be a good resolution to this. Instead, Democrats are saying, let's impeach President Trump because we don't know what the Constitution means. It's hardly a settled issue. Trump spent the money in any event, and so the issue is actually moot. The military assistance funds, they were released on September 11th. On September 9th, the State Department funds, they were released. So there's not even a legal question. There's not a ripe issue for the court to consider, and certainly not a ripe issue for Congress to consider, since the president actually went forward and did the spending anyways. Now, arguing about the constitutionality is, in fact, a complex question. But Trump and the members of Congress, they worked it out. And OMB, they released the funds. Now, a better question, and I'll leave you with the close here, is what to do about these bureaucrats at the State Department, the Defense Department, the National Security Council, and yes, perhaps former National Security Advisor Bolton, if he was siding with them, who briefly thought they alone could apportion the monies without Office of Management and Budget's approval to release the monies, while the President and Congress negotiated a resolution to the funding dispute. It is they, not the president, who are acting outside of the law and should be subject to reprimand. When it comes to the execution of foreign affairs powers, employees of the executive branch must act in accordance with the president's policies, or else it is they, not the president, who are the ones acting above the supreme law of the land, which includes the Constitution's Article 2 vesting of executive power solely in the president. That's the commentary. This is Robert Romano, Vice President of Public Policy with Americans for Limited Government, dailytorch.com. Hit that subscribe button, ring the bell for notifications, and have a good day.